So one of the biggest frustrations that landlords deal with is evictions that go nowhere. They file an eviction, they get to trial, and the judge turns them away, says, sorry, no eviction for you. And one of the biggest reasons for that is bad notice. Today we're going to talk all about why your notice to vacate might be dead on arrival. Let's get started. So the notice to vacate tends to be one of these things that sometimes can be a bit complicated for a landlord, particularly a landlord who hasn't done this sort of thing a lot. If this is your first time trying to evict somebody and your first notice to vacate, there are a few things that maybe don't come across as obviously needed, particularly if all you hear from the court is just deliver a notice to vacate. It sounds simple, but there are specific requirements out of Chapter 24 of the Texas Property Code that make it not simple. Let's talk about a few of those now. Landlords, you're going to want to stick through all 5 of the tips that I'm giving you on the things that destroy notice to vacate. All the way to the end, the best one is waiting for you. The first, believe it or not, is the date. What is the date that you put on your notice? Do you even put the date on the notice? The timing of your notice itself is an important factor in your notice to vacate. If you're taking your case to an eviction trial and it cannot be clearly established what date the notice was served or from what date the notice becomes effective, these issues can defeat an eviction. Very simple. On your notice, put the date and make sure that the date that's on your notice is actually the date that matches your date of delivery. Now, it doesn't matter if you're delivering your notice by U.S. mail, in person, posting on the inside of the door. That's secondary. What matters is that the date itself makes sense. I don't know how many times I've had a client come into the office and say, well, here's a copy of the notice to vacate that I delivered. And I asked them, why does this have last year's date? Oh, it's a typo. Or why does it say February 3rd when you're telling me you didn't deliver it until February 12th? Well, it was the original copy I had and I didn't have time to change it. Neither of these is a good excuse. Make sure that it is clear that the date that's on your notice is the actual date. Now, sure, if it's a typo, that can probably be explained away, but the more things you're having to explain to the court, the less likely it is that the court's gonna go along with you. If it is clear on its face that you delivered your notice on date X, that's one less thing you actually have to prove. Next, the names on the notice. This is another deceptively simple thing. However, if your lease features 2 tenants, then the names of each of those tenants better be in that notice. If you're only delivering notice to one tenant, but you're seeking to evict everyone who lives in the house, this could prove difficult for you, particularly if the people that you're trying to sue are, for example, roommates. The fact that you served one roommate may not be sufficient to serving them all, particularly if the notice doesn't feature a demand for possession from all of them. It could send a confusing message as though you're only kicking out one. Make sure that it is explicitly stated in your notice to vacate who exactly is going, because a proper notice to vacate has to demand possession from everybody. You cannot be selective in your notice because you also can't be selective in your eviction petition. So if there are 3 tenants listed on the lease, make sure they're all listed in your notice to vacate and demand possession from each of them. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. Now, what is a demand for possession? So many times landlords come in with very flowery language in their notice. It says something to the effect, if you fail to adhere to the proclamation in the stated document before you, I will proceed with legal ramifications against you heretofore. Listen, you're complicating the matter by adding a bunch of language that ultimately amounts to nothing. A demand for possession is strictly you saying, tenant, get out. That's it. You are terminating the lease and demanding that the tenant leave. Don't talk about or don't try to confuse the matter with legalese. It doesn't make your notice any better, particularly if a court cannot point to a definitive demand for possession, then your notice is dead. It doesn't exist. It's not actually a notice to vacate. On that point, if instead what you're doing is terminating the lease, please note that is not a notice to vacate. The fact that you're bringing your lease to an end is not the same as demanding immediate possession. If you're unsure what the difference is, believe me, I've got videos on this channel that explain the difference between a notice to vacate and a notice of termination. You'll want to watch that. Next, what is the basis for the eviction at all? If you're demanding possession because the tenant violated 5 provisions of the lease, mention each of those violations. Your failure to give proper notice may be cause for a court to kick out your notice as insufficient. If there is unpaid rent and an unauthorized occupant and destruction to the property and an unauthorized pet and some other violation, list each one in your notice. Because if you fail to do it and then later want to add it into your eviction petition, again, you might have an issue that you did not properly inform your tenant of that violation. If your tenant has violated the lease and that violation allows you to terminate their possession of the premises and allows you to demand that termination in a notice to vacate, make sure that you have clearly listed that violation in the notice to vacate. Don't give an excuse for someone to say that you delivered insufficient notice, because everything that you plan to base your lawsuit on should be in that notice. Finally, the last thing that kills your notice to vacate is the method of your delivery. The fact is, the Texas Property Code has strict guidelines for how a notice to vacate can be delivered. And if you don't stick to those guidelines, your notice is dead. You can deliver the notice and put it in the hand of an occupant of the premises 16 years of age or older. If you don't know that the hand you're putting that notice in is an occupant or at least 16 years of age or older, don't leave that notice in that hand. Go to somebody else. An occupant 16 years of age or older. Don't give it to grandma. Don't hand it to the neighbor. Don't give it to the boyfriend. Unless they're an occupant, they don't get notice. You can also affix the notice to the inside of the main entry door. Let me explain how this works. Inside means you open the door. You stick the notice to the inside part and then you close the door. Now, you may say, Ernie, there's no way I'm going to go in. That tenant's a psychopath. If I open that door, they're going to shoot me. That ain't happening. So I'm going to stick the notice to the outside of the door. No, don't do that. That's improper notice. It won't fly in the courts. You can't stick the notice to the outside of the door without following a whole other set of rules. I do another video on this. I go in depth. If you want to watch that video, watch that video. For now, just don't do it. Don't stick it to the outside of the door. It doesn't work. But if you're going to stick it to the inside of the door, again, open, stick, firmly affixed, close the door, you're done. So if you can't put it in someone's hand, if you can't open the door and affix the notice to the inside of the main entry door, then your last option is your best option. It's the one we recommend, our #1 blue ribbon winner every time. You send it by regular and certified mail. Let me show you. You're going to draft 2 letters. This one is just your regular mail letter. It's the exact copy as this one, which is your certified letter. And this certified copy is going to be tracked using this special number. However, you're going to mail both of these at the exact same time. An exact copy of the exact same notice to vacate, the original which you will keep in your file, But an exact copy of your exact notice to vacate will go one in here and one in here. And you will take these to the post office together. You'll mail both of them together on the exact same day. And that day will be reflected on your receipt, which you'll keep. It's great evidence when you're preparing your eviction for trial. You will then mail both of those letters by way of the U.S. mail. You'll be able to track when the letters arrive. Now, you may be saying, but Ernie, I've sent certified letters before in the past and they never arrive because the tenant will not go and pick up that letter. Or when the letter carrier comes to their house, knocks on the door, nobody answers. That's fine because the tracking that this little number will give you at USPS.com is going to indicate once that letter was either A, delivered, or B, attempted delivered, which is just as good because we know that logically, if both of these letters were put in the mail on the same day and this one was attempted delivered, that same letter carrier had this letter in her bag. And while she attempted and was unable to deliver this one was actually delivered. And so that starts the count at day 0. You count 1, 2, 3 days after that, and you file on day 4 or thereafter. If you can prove proper delivery, you're good. But if you can't, your notice is dead. If all of this blows your mind, if it's a little bit too much to handle, you're not alone. A lot of landlords have difficulty with their first go around. Don't make the mistake of trial and error with your first eviction. If you need help, ask. You've seen my phone number, my email address. I do not hesitate answering questions. If you need something deeper like a consultation, I would love to consult with you about your Texas-based eviction. Don't hesitate to give us a call or send us an email. If you're interested in learning even more of how to be a professional landlord, take a look at what we have right here. I'm sure you'll enjoy it. And until next time, happy leasing.